Okay. So, good afternoon. We have now come to the final keynote of the day, and it's a real honor to have with us Professor Gunther Teubner. Professor Teubner is Emeritus Professor of Private Law and Legal Sociology at the Goethe-Universität Frankfurt am Main in Germany. Over the years, his work has profoundly shaped the way, I think, we think about the relationship between law and society. One of his great contributions, in my view at least, has been to insist that social theory is not just an accessory to legal theory, but a vital part of understanding how law works in modernity. In this sense, he has helped define the field of social legal studies for an entire generation of scholars. I won't attempt to list his many achievements as a scholar in full, but I would like to mention just a few of his influential works. Law as Autopoietic System from 1989, Constitutional Fragment, Social Constitutionalism and Globalization of 2012, and more recently Digitale Aktanten, Hybride Schwärme, drei Haftungsregime für künstliche Intelligenz from 2024, co-authored with Anna Beckers. The title of Professor Teubner's talk today is Emergence and Personification, How the Law Makes Non-Human Entities Speak. The presentation will last approximately 45 to 50 minutes, followed by a Q&A session. So, without further ado, Professor Teubner, the floor is yours.
Well, thank you very much. You should know that I have always admired the Finnish legal academia for their theory obsession. I think in the spirit of theory obsession, we can also understand this conference today, which really will move legal theory forward, because in the 19th century there was this furious debate about the legal person, while in the 20th century there was not a big debate about the legal person. It seemed to be established in legal doctrine, legal practice, and only in the last years something else has begun, that new developments are emerging, new entities are coming up in the ecology and in computer practice, and suddenly the question of conferral of legal personhood is up again. And there is not only an adaptation of law to new realities, but also a normative agenda involved, which I would call responsive legal personification. Responsive legal personification. And in this spirit, I will give you my talk today on the theme Emergence and Personification, how the law makes non-human entities speak. I will begin with two questions and one thesis. Question number one. If indigenous knowledge about the sustainable use of nature helps solving the ecological crisis, must not the knowledge itself, but also its production, be protected? Does this mean that animistic practices, that is, the communication with animals, plants, landscapes, claimed by indigenous peoples, should be protected by fundamental rights? Question number two. If artificial intelligence have become powerful social actors, must they, on the one hand, be subject to stricter liability for their enormous potential of harm, and on the other hand, must the Constitution place artificial intelligence under the protection of fundamental rights, such as freedom of expression and artistic freedom? I shall not answer these questions directly with constitutional arguments. Instead, I take a detour. On this somewhat rocky detour, I will explore the relationship between two phenomena that are far apart from each other. On the one side, emergence, and on the other side, personification. My thesis is that emergent worlds pose a challenge to the law, since it cannot gain communicative access to them, due to the incompatibility of their elementary operations. Nevertheless, the law can indirectly give voice to novel non-human entities, which is collective actors, biosocial associations, or algorithmic calculations, and thus make them members of society. To support this thesis, I will present you 6 arguments and then sketch 2 case studies, one on algorithms, the other on biosocial associations. Argument number 1. Emergent phenomena form a hierarchy. Emergence theories were initially developed in order to grasp the difficult relationship between body and mind. In today's terms, between neuronal and mental processes. They turned against the sterile alternative of isolationist theories on the one hand and reductionist theories on the other. Emergence theories rely on combining 2 seemingly contradictory assumptions. I quote, "The paradox and perhaps also the appeal of the emergentist conception of mental causation arises from the combination of 2 ideas, the idea that mentality emerges out of and in that sense depends on the physical, and the idea that despite its ontological dependence, it begins to lead a causal life of its own, with the capacity to influence that which sustains its very existence, that is, the combination of upward determination and downward causation." Quote end. Emergency theories have also been developed for other phenomenal domains, not only body and mind. They provided an operational definition of emergence for a variety of complex systems, that is, natural, psychological, social, or artificial systems. In particular, social communications are understood as distinct emergent phenomena in relation to mental processes. Going further, systems theory identifies emergence phenomena within society, that is, at the interfaces between interaction and organization, and between interaction and function systems, among them the law, which is in itself an emergent system. The computations of autonomous algorithms are presented as the most recent case of emergence. The same is true for biosocial associations. We are neither dealing only with property emergence, nor only with the macro difference, instead systems emergence. System emergence is the appearance of a new self-organizing system with new elements, structures, and boundaries. A hierarchy of emergent levels that build on each other has developed as a result of historical random evolutionary processes. Neuronal systems, consciousness, communication, organization, function systems, and somewhat detached from these, autonomous algorithmic computations. The basal system is always characterized by the self-production of its respective elementary operation. At the same time, however, the basal system generates numerous external effects in its environment in random fluctuations. Of particular interest among these external effects are temporary events that are realized as discharges of energies from other layers of reality. These simultaneously generate a field of potentialities which direct similar events to possible connecting events. As soon as a critical mass of similar events is reached, they begin to influence each other via their respective fields, and the resulting concatenation of these events ultimately forms a new, emergent, self-productive system with its own operations, structures, and boundaries. Now, when basal systems generate emergent systems in this way, a whole hierarchy of emergent level is formed. Their elementary operations differ fundamentally from one another. And this is the reason why they are mutually inaccessible, despite their origin in the respective basal systems. This is my central argument on which the whole thing builds. So the reason why they are mutually inaccessible despite their origin in the respective basal systems. So, electrical impulses in the neuronal systems, thought operations in consciousness, communications as the synthesis of message, information, and understanding, binding decisions in organizations, binary coded operations in function systems, algorithmic computations. None of these elementary operations can be connected to the other. This is their inaccessibility. Now, digital technology, what is distinctive about it is the specific manners of its emergence. Rather than emerging as another layer in the pre-existing hierarchy, the technology forms a layer of a different, newly established hierarchy. It was created through a strange inversion of emergence as submergence. While the digital hierarchy works now from the bottom up, it has emerged from top to bottom. On the top was the semantic richness of analog communication that has been translated into mathematical formalization, which in turn has been translated into binary software computations according to the pattern 001-00111, which have been finally converted into electronic impulses in the hardware. The result of this submergence is a new parallel hierarchy of emergent elementary operations in digital space. It starts down there with hardware impulses, building on software computations, then comes human-machine interactions, digital hybrids. So these hierarchical levels are themselves, all of them, self-organizing systems. Now, if emergent means that the operations of the different hierarchical levels cannot have access to each other, then this is particularly consequential for social systems. Since it is impossible for them to reach other emergent systems with their elementary operations, they cannot communicate with them, but only communicate about them. So we cannot communicate with the neuronal systems, nor can we communicate with computers. We can only communicate about them. So this is argument number one. Now comes argument number two. Law gains access to inaccessible emergent systems. Again, starting point, the elementary operations of law have no access to those of other emergence levels. Legal acts, legislation, court decisions, contracts, they cannot connect directly to decision-making chains in organizations, nor to cognitive processes of autonomous algorithmic computations, or to biosocial associations. Vice versa, the emergent entities cannot participate in legal communication, cannot file lawsuits, cannot exercise subjective rights. Legal communication by other social systems such as organizations and functions is excluded, let alone biosocial associations or even algorithms. Now, this is the moment when personification comes in. The conferral of legal personhood opens up not direct, but indirect inroads via which legal norms ultimately find access to emergent worlds. More importantly, it makes silent, non-human entities speak within legal communication. Quote by Luhmann, personality came into being wherever the behavior of others was imagined to be chosen and to be communicatively open to influence through one's own behavior. These two conditions make personality. So personification makes it possible that events external to the law are transformed or converted into internal legal communications, which are then attributed, and this is the important thing, attribution practices within the law, which are attributed to the newly constituted persons as their actions. Here is the miracle of the legal person. The miracle of the legal person. The comparison with the miracle of incarnation, remember Christmas? Whereby transcendent beings find entry into the world of immanence through their transubstantialization is entirely appropriate. The comparison with the miracle of incarnation, whereby transcendent beings find entry into the world, is appropriate. Instead of et incarnatus est, it is now et incommunicatus est. In the legal personification of non-human entities, it reads et juridificatus est. To outline the following arguments in advance, personification allows the law to internalize emergent, external, non-human entities, organizations, algorithms, and biosocial associations as quasi-actors, albeit not these entities themselves, but only as semantic artifacts. That is present. So the distinction between the entity and the semantic artifact person is fundamental. These person fictions become attribution addresses for legal acts. They consist, so the legal persons, they consist of nothing but a bundle of expectations. So a person is nothing but a bundle of expectations and a multitude of legal norms directed at the person. Moreover, personification triggers a new dynamic. Emergent phenomena outside the law, which are reconstructed as persons within the law, become fully fledged partners in legal communication. Finally, the internal legal communication with the new participants in turn generates external legal effects on the substrate, so the entity, the human being, or the organization. Their mutual influences ultimately create a co-evolution of the legal person and their substrate. This was argument number 2. Now comes 3. 3 misunderstandings of the legal person. At this point, some deep-seated misunderstandings need to be rejected. Deep-seated because they refer to a long tradition on the subject and the person. The first misunderstanding is the usual identification of persons and human individuals. So persons are individuals, no, they are not. And worse still, the equation of persons with either people, with bodies, subjects, and individuals. All that is wrong. It is equally common to equate person and non-human entity, more generally the person and its substrate. The emergent entities are mute, and they remain mute. Via their elementary operations, they can communicate neither in law nor in society. Only the process of social and legal personification, the construction of the semantic artifact person, gives them a language. Contrary to a widespread view in law and society, it's by no means the external entities themselves that can communicate. Instead, within the law, and within other social systems, their elementary operations are reconstructed as communicative acts, which are then attributed to artificial persons as their internal systemic representative. For this reason, legal persons need to be distinguished from their substrate, human beings, as well as non-human entities. They are nothing but communication addresses. The second misunderstanding is close to it, but it's still different. It is the deep-seated juridical humanism that insists on reserving the legal person exclusively for legal individuals. Ironically, it allows one exception, one human exception for organization, with a not very convincing excuse that they are understood as associations of human individuals, but the organization itself is not an individual. So here, the human individual. Here, juridical humanism has long borrowed from the moral philosophical tradition, according to which autonomy is understood as the possibility of humans to determine themselves as being capable of freedom and reason and to act morally out of freedom and economy. Such a humanistic concept of the legal person, however, from the very outset blocks access to other personification processes that are actually taking place today. This deprives the law of making the extra-legal, real, tangible behavior of non-human entities comprehensible by attributing them legal capacity to act in certain social situations and constructing them as addresses for attributing responsibility. Juridical humanism decrees a priori that animals, even if they feel pain, cannot claim protection of fundamental rights. Appointing Amazonas or Ganges as legal persons is said to be a regression to archaic animistic practices from the medieval times that were long, long overcome. In contrast, legal positivism, which is not so bad, which takes the autonomy of law seriously and treats the legal system and morality as separate domains, claims that the legal person has emancipated itself from the autonomous subject of moral philosophy, so that personification is made exclusively to legal and no longer to moral philosophical criteria. The legal subject is constituted only through the assignment of rights and duties, regardless of their content. This gives the law the freedom to confer personhood to other non-human entities, and this is a kind of formality in the concept of the legal person, deprived of its moral connotations. But it is precisely this formality of the legal person that allows the law to react productively to new developments that drastically expand the circle of members of society. A third misunderstanding concerns the reality status of the legal fiction person. In which of the many worlds under the sun is the legal person created? For some scholars, the legal person is only a fiction in the mind of lawyers. Take the legal economists. They ironize the legal personification of organizations as a hallucination in lawyers' brains. They call it a trap, a fiction. In contrast, Scandinavian legal realism takes this very serious and sees the legal person, like other legal artifacts, as a mental reality in people's minds that can be researched using the methods of empirical legal psychology. And there's the old authority of Max Weber, who said there is no such thing as a collective personality which acts. Weber understands the legal person as an idea in the minds of judges, civil servants, and the public. Quote, Max Weber, such collective entities have a meaning in the minds of individual persons only. In the individual minds of individual persons only. However, this localization of the legal person in individual consciousness misses the relevant institutional consolidation, in social life, that the legal person experiences in the world of communication, not in the world of the mind, which is independent of the subjective meaning of individuals. Gives the legal person a kind of social reality. Argument number 4. Legal fictions make contact not only with one, but with two emergent worlds. Hans Kelsen captured the pure self-reference of legal personification most clearly. Quote, a legal person is the unity of a complex of legal obligations and legal rights. Accordingly, the legal person has nothing to do with the human individual. Instead, it is nothing but a bundle of legal expectations. Take this seriously. A bundle of legal expectations and the mere address of attribution for rights and obligations. The legal person is a partial legal order, an ensemble of norms, and not a full-fledged individual. All that is convincing. However, what Kelsen remains silent about are the multiple references of the legal person to its environment, for instance, the dirt reality, in particular to its substance. Self-reference of the legal person and its peculiar hetero-referential relations go hand in hand. This is important. The legal person remains the self-referential product of the law, a fiction, but realizes simultaneously two types of hetero-reference. One is the reference to the outside substrate. Take the corporation as a legal person, the state as a legal person, so it's a different outside substrate that the self-referential legal entity acting its name develops internally. And second, the real effects via structural couplings that it exerts on its outside substrate when the outside substrate internalizes the legal person's obligations, when organizations obey what the law is prescribing the persons. Such contacts exist between person and substrate not only when the individual is reconstructed as the semantic artifact person. Beyond the well-known personification of humans, the law has long since extended the circle of its person artifacts to organization. This is well known from Roman law. Today, the law is beginning to appoint biosocial associations, for example, the Ganges or Amazon, and algorithms, for example, electronic agents or text generators like ChatGPT, as legal persons. At the same time, it attributes a whole variety of characteristics to these persons, such as rights, duties, and action capacities. And vice versa, the legal persons generate perturbations within their substrate, which then strange their structures. And so the important thing is that there is a fiction in the law which has strong external effects to its substrate. Personification creates in the law an independent center of activity with internal and external effects. The personification of organizations, biosocial associations, and algorithms, they transform huge events outside the law into eloquent legal acts. In system theory language, the external event is reconstructed internally as a triad of utterance, information, and understanding, and attributed to the person construct. The one external event that the non-human entity generated is tripled within the legal system. There is a single organizational decision, or a single algorithmic computation result, or a single aggregation of interest in the biosocial association. So these are the outside events. And they are internally dissolved into a trias. Firstly, into the legal act of the legal person, which secondly transmits a legally relevant declaration, contract, or legislative act, which thirdly triggers an act of understanding in the declaration of another person. So all this happens in this artificial sphere of communication with the artificial fictions of the persons. Personification thus considerably increases the production of meaning in law far beyond the legal communication between humans. To repeat, the legal person is not only a self-referential construct of the legal system that replicates human and non-human entities in law and serves as a point of attribution for rights, duties, and actions. Legal personification simultaneously creates an additional real point of contact between the law and emergent phenomena, due to whose influences the semantic artifact and its properties change. In the opposite direction, legal personification is able to simultaneously change the behavior of external entities with the help of legal norms of the person construct. Law's person fiction exerts a real influence on them, on the cognitive processes of human minds, on communication within collective actors, on cognitive and emotional processes of living beings, on human-nature relationships in biosocial associations, and on non-transparent computations of algorithms. Argument number 5. Social personification creates pressure for legal personification. The external relations of the self-referential legal person are further complicated because the influence from the outside regularly emanate from two different emergence levels simultaneously. One external effect is generated by the person's contact with the human and non-human entities themselves. Human beings claim their right to participate in legal communication. Biosocial associations demand from the law to create the conditions for their social and political participation. The animal's ability to suffer pain demands protection of fundamental rights. Digital text generators create serious liability gaps within their risky actions. In this way, emergent worlds exert pressure on the law to enable them to participate in legal and also in social communication. This is the one external effect that comes from the entities themselves. The other external effect is not triggered by the entities themselves, but by social communication outside the law. For their part, various social systems constitute the non-human entities as social persons and then demand their stabilization from the law. How does the law react to these pressures from two external emergent levels? So, to what I have said so far, it must now explicitly added that a clear distinction needs to be made between personification in law and other social contexts, something which Hans Kelsen never did. Social personification, social personification, economic personification as a market actor, and legal personification are independent processes but influence each other at the same time. Certain external entities are reconstructed not only in the law, but also they are reconstructed as social persons in the form, again, of semantic artifacts, not only in the legal system, but also they are reconstructed in symbol interaction, in conversations, more formalized in organizations and function systems, especially in politics and the economy. Politics creates its actors, the states, and the economy creates its actors, the market actors. So restrictions are imposed by social, political, economic, scientific norms on these semantic artifacts. Personification, therefore, also occurs on a massive scale outside the law. In various social systems, entities from emergent worlds are personified, that is made into communication partners as social actors in their specific context. So collective actors are there, right? Are there in the different social domains. Each social system creates its own persons with their own characteristics. Homo economicus, Homo politicus, Homo juridicus, Homo sociologicus, they all differ in their characteristics, but they are all semantic artifacts. When social communication institutes non-human entities into new quasi-actors, an almost irresistible institutional pressure on the law arises to constitute their limited or full legal personality. That is what we have experienced in the economic corporations in the 19th century. And they were there as collective actors in the economy, and they made pressure on the law to constitute them as independent legal persons. As soon as social practices treat organizations or biosocial associations or algorithms as actors, something we can observe today, legislation and courts have a considerable burden of argumentation if they want to deny them legal capacity. So this is what we have to observe today. As already mentioned, however, the personification pressures on the law do not only emanate from various social systems, but also, as I said, from the non-human entities themselves. At this point, emergence reduces to absurdity the legal positivist omnipotence fantasies that is at the law's discretion to personify all possible objects. To quote an eminent German law professor, any object can become a legal person. Is this true for the table? This ignores the fact that the external entities themselves also they act as a restriction on possible personification, which the lawyers like to ignore. Well, when they theorize, in practice they do. The law only personifies if it can presuppose certain characteristics of the substance of the legal person. The legal system searches for credible indications of attributing the ability of legal communication to the entities. Not to all, but only to some where they think that they give this a certain authority to them. That is the chances of their legal addressability. Argument number 6, personification exerts repercussions on human entities. The central role in the downward influence from person to substrate is played by the transfer of expectations. Expectations serve as transmission belts between the emergent and substrate systems. The emergent system provides the substrate system with complexity in the form of expectation directed at the highly individualist semantic artifact of the person. While the elementary operations of basal and emergent systems remain inaccessible to each other, expectations, that's the interesting thing, are capable of bridging between emergent levels. They have the same if-then structure in both worlds. However, here the difference to the standard account of internalizing social expectations comes to the fore. The substrate is not bound by the expectations directed at the social or real person. Instead, it's only exposed to them and forced to respond by either accepting or resisting according to its own criteria. Only this is their binding effect. Binding norms directed at the person, where they are binding, are transformed in the basal system into the binding disjunctions of acceptance, non-acceptance. So far for my 6 parallel arguments. Now let me make some remarks on 2 case studies. The first one, algorithms as legal entities. Algorithms are treated as social actors under 3 circumstances. First, emergence, digital calculations as the elementary operations of software systems are not accessible to the elementary operations of social communication. And conversely, the operations of the invisible machines cannot participate in communication. They belong to a different level of emergence. They take place exclusively outside society. At this point of inaccessibility of true hierarchy, emergent hierarchies, at this point, a new type of social system emerges, namely human-machine communication. It's a new emergent system which picks up the computational results of the algorithms and converts them into its own elementary operation, that is, communicative acts. Second, communicative preconditions or affordances. In human-machine communication within the emergent social systems, the machine is assumed to possess pre-communicative preconditions. Without these preconditions, computational results cannot be converted into communicative acts. Third condition, personification. The addressee of communication is no longer, or is not at all, the machine itself. It's not the addressee of communication, it's not participating. The machine remains in the environment of communication. Instead, the addressee is a semantic artifact constructed internally in the social system. So your conversation with ChatGPT or scientific conversation and so on, which is given a proper name such as software agent, digital actor, or algorithmic person. They are all constructs of the social system and not of the machine itself. When algorithms become social agents in various socio-digital institutions, especially in politics or business, market actors, political social bots, only under these conditions and not only due to their technical characteristics do the social pressures on the law arise to endow them with legal capacity. This search induces the law to make the following distinction. Only certain digital phenomena are to be recognized as legal persons, while others are not. The reason is that the law will not find any credible indications of communicative preconditions in the hardware itself and the electrical impulses generated there. They cannot be converted into communication. As already said, they need to obey 2 general conditions for social agency and legal personhood. Their utterances must appear in communication as contingent decisions of a communication partner, and it must be possible to influence them by communication to give meaningful answers by asking questions. So try this with the electrical impulses in the hardware. Doesn't work. But text generators fulfill both conditions. Now, make the test yourself. When they scan the internet, they make their own decisions of what is the relevant information, not unlike what scholars do after extensively reading the relevant literature. So that we are doing all the same time in armchair scholarship. Reading around and then selecting some aspects as the new thesis. At the same time, their answers are influenced by the user's communication, the so-called prompting. So the 2 conditions are fulfilled. Now, private law cannot just personify them. fully. Rather, they must carefully calibrate their legal capacities. Since today algorithms act regularly in the name and the interest of the human principles, they can only acquire limited and partial legal capacity. So, personal is a gradualized concept. Private law should grant them only the right to act as representatives capable of making decisions in principal-agent relationships and to conclude binding contracts with third parties with a direct binding effect on the principal. So in addition, they act as vicarious agents for whose wrongful decisions in tort law and in contract law, the vicarious liability of the principal is appropriate. But this is where, for the moment, the legal capacities of algorithms end. Perhaps, in the foreseeable future, they could acquire full legal personhood as e-persons. They could assert property rights and could contract in their own name and interest in profit orientation. But then they would also have to be exposed to personal liability, provided that they are equipped with sufficient financial resources, equitable capital, or compulsory insurance. Of course, this recourse to their technical and social properties competes with other legal policy objectives or institutional requirements that can weaken or strengthen the tendencies toward their legal personification. So far for private law. Constitutional law. Should algorithms which have considerable creative potential in the field of science, art, or public communication, should they be protected by fundamental rights against state intervention and against the intrusions of the economy and other expansive social subsectors? The still prevailing doctrine rejects this apodictically. However, pioneering analyses have plausibly declared the results of digital calculation as legitimate candidates for fundamental rights protection. They developed a legal triad of fundamental rights for algorithms: institutional, accessory, and original. Institutional, it seems immediately plausible to protect algorithmic activities by fundamental rights, understood as an institution, institutional theory of fundamental rights. If they act within a very institutional context, then it would be downright absurd to exclude their autonomous decision from protection in art, science, and public debate. Accessory protection comes in when algorithmic and human activities are closely intertwined in a hybrid. This is particularly the case with human-machine associations. In these situations, it's no longer possible to identify the respective parts of the machine's and human's actions. Thus, the hybrid association itself becomes an actor, a person, and becomes the subject of fundamental rights. The most sensitive issue is original protection of fundamental rights that recognizes autonomous algorithms themselves, or take a robot, as bearers of fundamental rights. Arguably, the adequate analogy basis lies in their autonomous activities, and it's only logical to protect not only the activities of humans, but also those of autonomous algorithms. However, a major caveat must be added here. Even if algorithms are recognized as fundamental rights subjects, in principle, it must be carefully examined for each fundamental right whether the technical affordances and the relevant socio-digital institution justify its application. And if so, whether a generous endowment of fundamental rights does not create unreasonable dangers to society, which are in the center of the debate today. Okay, so far for the first case study. The second one is biosocial associations. For Western observers, it comes as a surprise that a considerable number of constitutions in the global south declares rivers, mountains, and entire landscapes to be legal persons. In India, the holy river Ganges, and Yamuna; in Colombia, the Amazon; in New Zealand, the river Vahanamui, have been declared legal persons, and constitutional norms are supposed to extend fundamental rights to them. It is too narrow to see this only as an objective guarantee of nature conversation. the claim to give nature a legal voice is better understood as the elevation of human communities to the status of formal organization which acquire action capacity through personification, however with a special feature that their identity is territorially defined by the name Amazon and so a whole region around them becomes personified as a human association. However, such a collective actor, which is based on Western interest groups, still lacks the originally intended connection to nature. So how do we come to grasp with that? Instead, it needs to be based on the concept of biosocial association that tends to understand humans as related to and within holistic living ecosystems in the context of complex systems of reciprocal and intertwined rights and responsibility of use and care. So the ecological manifesto. In this situation, a different emergent phenomena comes up. A previously non-existent or only latently existent human-nature association. Bruno Latour's concept of the hybrid, which has defined human algorithm associations, proved useful. Mute natural beings have their own activity potential, but they are paralyzed in their speechlessness. Legal personification unites them and human participants in an emergent association, giving them a voice in social life. The human members of the hybrids are supposed to act as trustees for the hoped-for unity of humans and nature. They exercise self-governance on behalf of the hybrid. But the question arises, are such human-nature associations not in danger that their human members will reassume the old domination of nature under the new sign? In order to institutionally ensure that nature-human associations authentically represent the interests of the eco-complex concerned, two alternatives are offered. Either terrestrial ties between people and nature or communicative contacts. Recognizing terrestrial ties in biosocial associations which do not suffer from the loss of people's relationships to their material living conditions and the deprivation of secure ground beneath their feet should be acceptable for a Western understanding of the Constitution. This is Latour. It would place indigenous knowledge which is based on the century-old experience of people living there with nature under the protection of an ecological constitution and thus assist in overcoming the ecological crisis. However, this view ignores the indigenous people's claim that humans and natural beings actually communicate with each other. Now it becomes difficult for us. Will this not amount to rehabilitation of animistic practices which have long since the medieval times overcome? But according to a central requirement of modern environmental policy, indigenous knowledge is considered extremely valuable in overcoming the crisis. It does not suffice to protect knowledge as a merely static information complex. Rather, it is the whole process of knowledge production that must be stabilized for the future. Indeed, animistic practices need constitutional protection. This certainly applies to the constitution of the Global South. Western societies under the influence of functional differentiation and especially autonomization of science, they cannot be expected to protect in their field animistic practices in their constitutions. However, a conflict of laws perspective would realize the principle of interculturality in interpreting the legal person and recognize indigenous cosmovisions of the Andean and Amazonian regions. Similar to the principles of private international law, constitutional conflict of law norms would have to be developed that recognize the constitutional norms of the Global South and refuse recognition only when they blatantly contradict the national ordre public, for example, in cases of unacceptable discrimination. Whether communication between non-humans and humans within hybrids can be identified, and whether a genuine social system thus emerges in their relationship, depends on the interactive dynamics within the hybrid. If the non-human components are treated as persons, a rather strange asymmetrical communication takes place in the internal relationship. People talk to natural objects as if they were subjects. Although this is based on the fiction that the natural object has communicative abilities, the fictional character is irrelevant as long as they successfully maintain the flow of communication through their contributions. Now, this is decisive. Insofar as the communicative process within the hybrid identifies events that can be understood as utterances by the non-human containing a certain information, a genuine social system will indeed emerge between human beings and natural beings. The answers that the humans receive from natural phenomena to their questions thus fulfill everything that the triad of information, communication, and understanding requires. Therefore, if one accepts the cultural self-understanding in the societies, which has been socially institutionalized there, not just in the minds, a genuine social system emerges in the asymmetrical interaction of humans and non-humans, even if the non-humans can by no means be granted the psychological competences of the humans. All this leads to the conclusion that the voiceless, the mute natural processes do indeed have access to communication in society, albeit in an indirect way, not via personification. Law plays a special role in this dynamic. It stabilizes the fragile existence of non-humans by granting these hybrids the status of legal persons, attributing to them the ability to act, not only within the hybrid but also outside the hybrid, giving them rights, imposing duties on them, and making them liable in various areas of legal responsibility. In particular, their access to the courts opens up the law to ecological interests in the strict sense, not only by certain trustees, but in the strict sense. There are now increasing signs that the law is beginning to revise its procedures and concepts to provide institutional support for the new participants in the political ecology, declaration of ecological rights in nation-state constitutions, the gradual juridification of animal rights, the transition in legal language from the semantics of the state protection of nature via ecological interests up to inherent rights of living processes, granting legal standings to environmental organizations, the gradual conceptualization of environmental damage without attribution to the individual and to a party, and more recently, the constitutional conferral of personhood to natural phenomena. All these are indicators that the law is preparing to give a voice to silent nature, and this is what I would call the normative approach, normative demand of responsive legal personification. Thank you very much for your attention.
Thank you very much, Professor Teubner, for this wonderful talk.